This public hearing of the Joint Standing Committee on Treaties for its inquiry into the Convention between Australia and Portugal Republic for the elimination of double taxation in respect to taxes on income and the prevention of tax evasion and avoidance. I begin by acknowledging the traditional custodians on the land on which we meet today and pay my respects to the elders, both past and present. I'd also like to extend that respect to any Aboriginal or Torres Strait Islander people joining us today. In accordance with the committee's resolution of 4th August, this hearing will be broadcast and proof and official transcripts of the proceedings will be published on the Parliament's website. I remind all members of the media for the need of fair and accurate reporting of the proceedings of the committee. I now welcome representatives of the Department of Foreign Affairs and Trade, the Australian Tax Office and the Department of Treasury to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you are appearing before the committee?
Miss Ronita Ram, I'm a Director in Australian Treasury.
Mr Andrew McCrossin, I'm an Assistant Commissioner in the Tax Council Network Group at the Australian Taxation Office.
Ms Naomi Mason, I'm the Treaties Manager at DFAT.
Thank you. Although the committee does not require you to give evidence under oath, this hearing is a legal proceeding of the Parliament and therefore has the same standings as the proceedings of respective houses. The giving of false and misleading evidence is a serious matter and may be regarded as contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. It is the responsibility of witnesses to accurately record any questions on notice that are taken. Would you like to make an opening statement before we proceed?
Thank you. Yes, Chair. Thank you for the opportunity to provide an opening statement and to appear before the Joint Standing Committee on Treaties. Australia and Portugal share a close friendship and significant people-to-people links with around 73,000 Australians of Portuguese ancestry and 17,050 Australians born in Portugal. We also have a deepening commercial relationship with growing trade and investment links. In the period from 2018 to 2023, two-way trade between Portugal and Australia grew by 58%, with two-way goods and services trade now valued at $835 million, with another $1.6 billion of Australian and Portuguese capital invested in each other's countries. On 30 November 2023, Australia and Portugal signed the first tax treaty between our two countries. Negotiating a bilateral tax treaty with Portugal is a key means of further strengthening the economic relationship and cultural ties between our two countries. The key features of the treaty are reduced source taxation, country taxation for cross-border payments of dividends, interest and royalties in both Australia and Portugal. This is expected to help create a more favourable bilateral investment environment and to make it cheaper for Australians to access capital and technology from Portugal. It will also support Australian businesses looking to expand into Portugal. The treaty also contains integrity provisions to ensure that the benefits of the treaty are only granted in appropriate circumstances, consistent with the recommendations made by the OECD and endorsed by the G20. These rules are intended to address base erosion and profit shifting practices through tax treaties and minimise opportunities for double non-taxation. The integrity rules contained in the treaty are consistent with ongoing international efforts to improve tax system integrity. In addition, the treaty provides for greater administrative cooperation between Australia and Portugal. For example, it contains important rules authorising the revenue authorities of Australia and Portugal to exchange taxpayer information in respect of taxes imposed under the treaty to help detect and prevent tax evasion. The treaty also contains provisions providing taxpayers with a dispute resolution mechanism if they believe that they have not been taxed in accordance with the treaty. As explained in the national interest analysis, the new treaty is in Australia's national interests. The treaty will reduce taxation barriers to trade and investment between Australia and Portugal, reduce the cost of Australians accessing technology and capital from Portugal, provide more certainty for taxpayers who earn income in Australia and Portugal, strengthen integrity measures to reduce tax evasion, and strengthen our bilateral relationship with Portugal. The treaty is largely based on the OECD model tax treaty with certain deviations to protect Australia's interests. For example, the treaty contains Australia's key provisions to preserve Australia's taxing rights over the exploration and exploitation of Australia's natural resources. The treaty will also support the government's plan to make multinationals pay their fair share of tax through added integrity measures and mechanisms to facilitate greater cooperation and information sharing between tax authorities to detect and combat tax evasion. The treaty also gives effect to the base erosion and profit shifting recommendations made by the G20 and OECD to ensure that the treaty benefits are only granted in appropriate circumstances, reflecting the government's continued commitment to tackling tax avoidance and tax planning practices. Finally, tax treaties also help reduce uncertainty and administrative burden for individuals looking to study, live and work overseas, thereby facilitating labour mobility. This tax treaty therefore presents a welcome opportunity to deepen our cultural ties and people-to-people links with Portugal, a country with many shared values with Australia. I thank the committee for the opportunity to make these opening remarks, and we are happy to take questions. Thank you.
Did either of our other witnesses have anything further to add at this stage?
Nothing from me.
Yeah. Okay. So the first questions that I had before we go to my fellow committee members, just in relation to this particular convention, is it in line with other conventions that we have? Are there any differences? Is this sort of is there anything new in this treaty? And where do we have those other agreements? And talk us through any differences that we may have between those agreements and this agreement.
So this tax treaty between Australia and Portugal is largely consistent with Australia's tax treaty practice. We have a tax treaty network of around 46 bilateral treaties. They're mostly based on the OECD model. So there is a lot of commonality between all of the treaties, including this treaty, because they are all based off the OECD model, but there are certain departures that Australia seeks for in our treaty negotiations to protect our interests. For example, in terms of preserving some of our important general anti-avoidance rules and protecting our taxing rights over important assets like natural resources. So those form a key feature of our treaties across our treaty network and are a part of this treaty with Portugal. So it is largely consistent with our tax treaty practice, and we were successful in securing those features of the treaty. The treaty also, consistent with Australia's tax treaty network, provides for lower rates of dividend interest and royalty withholding rates. In the case of Portugal, Portugal agreed to provide lower rates for interest and dividends derived by Australian super funds from their investments in Portugal, and so that will help to provide higher returns for Australian workers and retirees. It is something that we do seek in our tax treaty negotiations. And in the case of Portugal, we did also include some rules relating to data protection, and that is consistent with each country's domestic law, and consistent with the Privacy Act in Australia, and is also consistent on Portugal's side with EU requirements. By and large, it's largely consistent with our treaty practice.
How many countries do we have similar arrangements with, and was there a need for Portugal to be dealt with now, or is it more that they were just next on the list?
So we have 46 bilateral comprehensive income tax treaties. That's that is quite a modest network. It's targeted at the countries which Australia has the most trade and investment relationships with. Portugal was included in the government's tax treaty program. Portugal initiated a formal request for negotiations for a tax treaty in 2020, and the government then publicly the previous government announced its intention to enter into treaty negotiations with Portugal in September 2021, and the current government reaffirmed that commitment in November 2022. There is currently no tax treaty between Australia and Portugal, so there are benefits to negotiating this agreement with Portugal, because in the absence of a tax treaty, cross-border income can be taxed twice.
No, that's okay, Senator. I just, we're good. We will keep going. I'll just see if Member for Spence has any questions.
Thank you, Chair. I just wanted to go to the national interest analysis and just just to get a bit of an idea of how it will improve the integrity of the tax system. So what is meant by it with regards to Australia-Portugal? Has tax evasion and avoidance been a problem between the two countries? And what other issues have occurred in the past in relation to the NIA?
I'm not aware of any specific instances of tax avoidance between Australia and Portugal, but perhaps from a framework perspective, what the treaty does is it puts in place mechanisms for the tax authorities of both Australia and Portugal to share information with one another, and that will help detect tax evasion. It also contains important integrity rules so that for example, one of the key purposes of the treaty is to avoid double taxation, but also to avoid instances of double non-taxation, and that's noted in the preamble of the treaty, and that is a minimum standard required by the OECD now in tax treaties to prevent tax treaty abuse, that we also try to prevent opportunities for low or no tax outcomes. So that is a feature which the treaty is adding. It's including those integrity rules. There are also other integrity rules in the treaty, for example, where a taxing right may be triggered if there's a permanent establishment in a country, and that can be circumvented by disaggregating time periods. So there's integrity rules to kind of aggregate time periods to prevent taxpayers from being able to avoid a taxable presence in a country. So it contains a number of those integrity rules which are part of the OECD recommendations, plus that broader framework of cooperation between the tax authorities and the Australian Taxation Office and their Portuguese counterparts.
Okay.
Senator, did you have any questions?
Yeah, just not on a general sense. I understand that it is comparable by and large with existing treaties, but Article 26, for example, in terms of data use, as digital systems become more prevalent and there is evolving legislation and approaches to data security here in Australia as well as other nations, do the clauses in here differ to other treaties or conventions that we have? And as it evolves, for example, for a new treaty, is that retrospectively worked into other treaties of those 46 that we have?
The treaty with Portugal does contain a standalone article dealing with the use and transfer of personal data that is obtained or supplied within the scope of the treaty. That's a feature of the Portugal treaty. Just in reference to your last question, it doesn't apply to, it doesn't retrospectively, for example, apply to other treaties in Australia's network. This requirement is something which was sought for consistency with EU requirements for Portugal, and Australia has also included a similar provision to this in our tax treaty with Germany, and that's entitled Protection of Personal Information in the Australia-Germany Treaty, and it's the principal statute in Australia which governs this is the Privacy Act. And essentially the treaty is maintaining consistency with our domestic law. It aligns with each country's domestic law.
Mm-hmm. And not that it would be a showstopper, but just to understand, paragraph 48, you say that the reciprocal nature of tax treaties means both countries can expect direct costs and benefits. Is there an assessment as to whether the costs will outweigh the benefits, or vice versa, or is that a moving feast depending on the movement of people and capital?
We generally tax we generally cost the first round costs of the treaty. So the first round costs of the treaty would generally be the reductions in tax rates, commonly for dividend, interest and royalty withholding. The costing for this treaty is negligible, and that has been reported through the budget process. The benefits of the treaty come through increased trade and investment, but they are second round effects, and those second round effects are harder to reliably quantify. So as part of our costings, we only quantify the first round effects, which is the reductions in tax.
Thank you. I have no other questions.
Great. So just a final question from me, just in relation to the national sort of interest analysis that was done. Some of the commentary was that stakeholders were generally supportive. So that, I guess, suggests that there were some stakeholders that weren't supportive or expressed concerns. Could you just sort of outline for us what issues were raised and why you believe that they've been dealt with, or sort of a response that you may have to some of the issues that were raised by some of the stakeholders?
Sure. So we conducted a public consultation process from the 16th of September 2021 to 31 October 2021, and that was following the previous government's announcement of the expanded tax treaty program, which named Portugal as one of the countries to be scheduled on the program. A number of submissions didn't touch on Portugal specifically. There was a specific reference in the submission by the Australian Custodial Services Association, which said that it supported negotiations with Portugal, but it was left at that high level. Other submissions, I think the Tax Institute of Australia, maybe one, spoke generally about the outcomes that they would like to see in tax treaty negotiations. They didn't mention Portugal specifically, but in terms of general outcomes, that feedback has been incorporated by us in terms of the positions they help inform the positions that we consider as part of the negotiations, and a number of the outcomes that stakeholders have sought we have achieved in the tax treaty with Portugal, including in relation to reducing double taxation in relation to dividends, interest and royalties, and on other specific types of income like fringe benefits tax income, for example, was mentioned in the submissions and is an outcome of this treaty. So not very many submissions touched on Portugal specifically.
Can I just ask, as a follow-up, in a few of our other inquiries that we've had in relation to treaty making, there's been concerns raised about the consultation that government goes down to engage with stakeholders. Can you just step out for us in relation to this treaty? Just give us an insight as to how you've consulted. Is it just a simple Google desktop search of who do we think are interested in this? Are people signed up? Like, how do you go about that process of consultation? Just more broadly for us, so that as a committee we can look at that bigger topic of consultation and treaty making.
We have conducted public consultation, which is a formal consultation process where we invite interested stakeholders to make submissions, and those submissions are available on Treasury's website if they're non-confidential. And so we seek feedback through public consultation processes. We have held two public consultation processes quite recently. So we undertook, as I mentioned, public consultation in September and October 2021, and in March to April 2024, and also November to December 2022, all via our website. In advance of negotiation, we may also reach out to the Chamber of Commerce from the relevant country to seek their views and input on anything that might be relevant to the treaty. And we also consult with a panel which is called the Tax Treaties Advisory Panel, and that comprises of tax experts on treaty issues, and that panel has representatives of peak bodies such as from the banking sector, the Law Council, from airline industry, from natural resources sector. So we also seek feedback through that means.
And given the nature of the work that you've got, like this is the treaty before us today, but if there's 46 other treaties that are similar, what's the pipeline of work? Is it a well-established consultation process where people, just expect there to be more things to be considered to provide feedback on?
Yes, we have consulted in batches quite recently on for other countries that are coming up through the pipeline. So our most recent consultation, which took place in March and April this year, that was following the announcement of tax treaty negotiations with Brazil, New Zealand, South Korea, Sweden and Ukraine. So submissions were sought and stakeholders are welcome to provide submissions on those countries, but also on the broader program as well. And we do receive broader submissions as well around countries that should be on the program and what sort of outcomes people would like to see in tax treaties. But for countries coming up in the pipeline of negotiations, they have all been part of the consultation processes as well.
And once the treaty's in place, is there that feedback loop to see how it's going, or is it just business done, move on until we renegotiate or need an amendment? Like, is there ever a feedback loop where you go back to those stakeholders to check in to see how it's going?
Ordinarily, if there were issues around a treaty, we would expect stakeholders to approach us if they have any issues. They may also approach the ATO. If there's... But
it's only if it's required. It's not mandated that you check in after 4 years or 5 years. It's only if an issue pops up.
That's correct.
Okay. I'll just check to see if there's any other questions.
Not from
Great.
me.
Okay. We're done. So I will just do my set of words at the end, wrapping up. So thank you for your attendance today. You will be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to any transcript errors. Please send your responses to any questions taken on notice during this hearing to the Secretariat by close of business 21st of February 2025. And I now declare this hearing closed. Thank you everyone for your attendance today. Thank you.
Thank you.